Welcome to the ICN's Training on Demand videos covering competition law and policy. This module focuses on the coordination between competition authorities and public prosecutors in the fight against cartels. Cartels have been called the supreme evil, the most egregious violations of competition law. Accordingly, the practice is subject to severe sanctions around the world and is a top priority for competition law enforcers. In recent years, an increasing number of jurisdictions have criminalized collusion or established some form of penalties for individuals involved in cartels. In many countries, there are two types of independent federal or state government agencies involved in investigating and trying cartel cases, both in the administrative and criminal contexts. On one hand, there's the Competition Authority, which is the legal body with jurisdiction to enforce anti-cartel legislation. On the other hand, you have the Public Prosecutor, the authority responsible for representing the public interest as government representatives before courts and tribunals for the prosecution of all kinds of crimes. Even though in some cases public prosecutors may not be specialists in competition law, as criminal enforcers they can play a very important role in the fight against cartels in many jurisdictions. Now, of course, criminal offenses are prosecuted in a variety of ways that can differ from place to place. Common law countries are usually linked to an adversarial legal system, while civil law countries generally adopt a more inquisitorial system. In some places, the Competition Authority must decide whether to try a case administratively or criminally. Other agencies in other places, depending on the seriousness of the offense or the available evidence, may pursue both. Regardless, effective cooperation and coordination between the Competition Authority and the Public Prosecutor is essential and must entail a common understanding of enforcement goals and processes to be pursued at different stages of proceedings. Just a couple of examples. Leniency coordination. Of course, leniency programs are extremely important tools for uncovering cartels. The ITAD has a whole separate module on leniency programs. They rely on predictability to ensure their effectiveness and therefore require close coordination between competition authorities and public prosecutors. To be effective, once granted, leniency should not be jeopardized or renegotiated by a different government body. Second, competition authorities must pay special attention to the evidence-gathering processes and rules and all the other safeguards which are built into the requirements of their legal systems. They must be aware of the implications of the use of evidence in both competition proceedings and criminal prosecution. Finally, even during the criminal phase, the support and expertise provided from competition agency lawyers who have experience prosecuting cartels may be critical for public prosecutors to secure a criminal conviction. In this module, colleagues from the Canadian Competition Bureau, the Brazilian Administrative Council for Economic Defense, and the Chilean Fiscalia Nacional Económica will be sharing their experiences, their expertise working with public prosecutors, and the initiatives taken to foster a more collaborative relationship. Thank you, and enjoy the rest of the module.
My name is Ann Salvatore. I am the Deputy Commissioner of the Cartels Directorate at the Competition Bureau. I've been at the Bureau for over 30 years, and many of those years have been dedicated to cartel enforcement.
And I'm Valerie Chenal. I am the team leader for the Competition Law Section with the Public Prosecution Service of Canada. I have been practicing competition law for the last 20 years, and I have been a federal prosecutor for most of my career. Together we'll be discussing the working relationship between the Competition Bureau and the Public Prosecution Service of Canada, also known as the PPSC.
In Canada, agreements among competitors to fix prices, allocate markets, or restrict output and bid rigging are criminal offenses under the Competition Act. Conspiracies are punishable by a fine of up to $25 million, imprisonment for up to 14 years, or both. The maximum punishment for bid rigging is a fine in the discretion of the court, imprisonment for up to 14 years, or both. The Competition Bureau investigates alleged offenses under the Competition Act and may refer matters to the Public Prosecution Service of Canada for prosecution. Given this division of roles, we continually seek ways to facilitate working together while respecting each other's independence. In order to collaborate effectively, we need to have a clear understanding of our respective roles, mutual respect, and trust.
Our roles are outlined in the PPSC desk book, the Immunity and Leniency programs, and the 2020 Memorandum of Understanding between the Commissioner of Competition and the Director of Public Prosecutions. We will refer to it as the MOU throughout this video. These documents also provide transparency and predictability for stakeholders. First, we would like to describe our roles during the two main stages of a case, the investigation and the prosecution.
Let's start with the investigation. Bureau officers conduct investigations under the Competition Act while seeking legal advice from the PPSC. It is the Competition Bureau officer's role to identify the object and targets of the investigation, to determine the structure and scope of the investigation and how to carry it out, and to gather, preserve, and organize evidence. If charges are laid, the Bureau prepares a disclosure package that will be provided to the accused. Generally, the Competition Bureau requests that counsel be assigned to a case at the beginning of the investigation.
Counsel will provide advice relating to four main areas. First, legal issues likely to impact an investigation or any subsequent prosecution. Here, counsel aims to reduce the risk that operational decisions, such as methods of obtaining evidence, will affect the admissibility of evidence at trial. Second, court applications made by officers, for instance, to obtain search warrants. Third, the referral of evidence to the PPSC to ensure that the referral package meets all legal and policy requirements. And fourth, any legal issues related to witness interviews.
Parties may apply under the Immunity and Leniency programs, which are jointly administered by the Competition Bureau and the Public Prosecution Service. In Canada, we use the term immunity to mean full immunity from prosecution, which may be provided to the first party either to disclose to the Bureau an offence pursuant to the Competition Act that it has not yet detected, or to provide evidence leading to a case referral to the PPSC. We use the term leniency to refer to lenient treatment upon sentencing for subsequent qualifying applicants who are required to plead guilty under the program.
The Public Prosecution Service has the sole authority to grant immunity or leniency to a party implicated in an offense under the Competition Act. The Public Prosecution Service follows the principles set out in its desk book to decide whether to enter into immunity or plea agreement with an applicant. The PPSC desk book is available on its website at www.ppsc-sppc.gc.ca.
The Bureau's role is to investigate the alleged offence and make recommendations to the PPSC to grant immunity or leniency.
The Public Prosecution Service consults with the Bureau and gives due consideration to its recommendations, but has the independent discretion to accept or reject the Bureau's recommendations. As outlined in the MOU, Bureau officers and counsel for the PPSC consult one another as necessary throughout the immunity or leniency process to ensure that all criteria is satisfied and the public interest may be served by granting immunity and leniency in appropriate cases.
There are four main steps during the immunity process. First, the initial contact or marker request. Second, the proffer. Third, the grant of interim immunity, which is a conditional grant of immunity that sets out the obligations that the applicant must fulfill for the PPSC to finalize the immunity agreement. The fourth and last stage, an immunity agreement granting final immunity, will be provided when the applicant's cooperation and assistance are no longer required. You can find more information about our immunity and leniency programs on the Competition Bureau's website at www.competitionbureau.gc.ca. The Bureau is responsible for managing the immunity and leniency programs, which includes accepting markers, taking proffers, interviewing witnesses, and collecting documentary evidence. If the applicant meets the conditions of the program, the Bureau will recommend that the PPSC issue a grant of interim immunity.
If the PPSC decides to grant interim immunity, the applicant, the Director of Public Prosecutions, and the Commissioner of Competition all signs the grant of interim immunity, which forms the agreement between the parties.
Once applicants have fulfilled their obligations under the grant of interim immunity, and their cooperation and assistance are no longer required, the Bureau recommends that the Public Prosecution Service grant them immunity.
As I mentioned earlier, the Public Prosecution Service has the sole discretion to grant immunity.
Under the leniency program, a party implicated in cartel activity may cooperate with the Bureau's investigation in exchange for lenient treatment in sentencing, as long as they apply for leniency before the Bureau has referred the matter to the PPSC for prosecution. The process is similar to the immunity process. Step 1 is the initial contact or marker request. Step 2 is the proffer. Once this is complete, the Bureau will ordinarily conduct interviews with key witnesses. At Step 3, the Bureau makes a leniency recommendation to the PPSC. In the recommendation, the Bureau describes the leniency applicant's role in the cartel, assesses the cooperation and evidence the applicant has provided, and recommends the terms of a plea agreement based on all evidence gathered over the course of the investigation.
As with immunity, public prosecutors have independent discretion to accept or reject the Bureau's leniency recommendation. However, the PPSC provides that the Public Prosecution Service should consult with the Bureau and give due consideration to its recommendations. Public prosecutors conduct and lead plea discussions with the leniency applicant.
The Bureau may attend plea discussions to assist the PPSC with any details about the leniency applicant's cooperation and the value of such cooperation to the Bureau's investigation.
The plea agreement establishes the terms and conditions under which the PPSC recommends to the court that the applicant be provided with leniency in sentencing. The Public Prosecution Service and counsel for the leniency applicant make a joint sentencing submission based on an agreed statement of facts. Under the terms of the leniency program, the applicant must plead guilty. The court alone ultimately determines the appropriate sentence.
Once the plea agreement is concluded, the applicant is expected to provide records to the Bureau. Interviews of the applicant's witnesses will then take place. These witnesses are expected to testify in any prosecutions of other parties to the cartel as required. With respect to outstanding parties, in other words, those that are not part of the immunity or leniency programs or have not come forward to settle their liability, the Bureau may refer evidence to the PPSC with a request that it commences a prosecution. The Bureau typically provides all relevant records pursuant to disclosure obligations at that time. Counsel ultimately determines what is disclosed to the accused if charges are laid.
Counsel for the Public Prosecution Service reviews the evidence and determines whether a prosecution is in the public interest by exercising their own independent discretion. Counsel assesses the evidence in accordance with the principles set out in the PPSC's desk book. First, counsel determines if there is sufficient evidence, and second, determines for each of the accused whether it is in the public interest to initiate a prosecution. Counsel then informs the Bureau of their decision as soon as possible. If counsel does not authorize the laying of charges, they will explain the reasons to the Bureau or recommend further investigation.
As a best practice, the Bureau and the PPSC consult each other throughout the investigation regarding any decision that is likely to have an impact on a prosecution emanating from a Bureau investigation. Competition Bureau officers also support the PPSC throughout the prosecution stage of a case. For example, the Bureau continues to preserve and maintain continuity and security of all evidence as it does during the investigation phase, provides all new relevant information to counsel pursuant to disclosure obligations, is available to review the facts of the case and disclosure issues with counsel, takes all necessary steps to ensure the availability of witnesses, attends pre-trial interviews of prospective witnesses by counsel, and keeps notes of such interviews for disclosure purposes, attends court proceedings when required, and carries out additional investigative tasks that are reasonably required by counsel. However, during a prosecution, the Bureau cannot dictate litigation positions to prosecutors or impose specific courses of action. The Public Prosecution Service has final authority over all decisions related to the prosecution.
Earlier, we talked about settlements under the Leniency program. Now we will cover settlements outside of the program. Public Prosecution Service Counsel are responsible for conducting all plea and sentencing discussions in accordance with the PPSC's desk book.
The Bureau provides detailed sentencing recommendations to the PPSC. When developing sentencing recommendations, the Bureau considers factors outlined in the Criminal Code of Canada, case law, as well as the maximum penalties stipulated in the Competition Act.
Public Prosecution Service Counsel consult with Bureau officers to elicit their views regarding the appropriateness of any proposed plea, sentence, or other resolution, and the Bureau's views are considered. If a plea agreement is reached, counsel will convey the substance of the agreement and its reasoning to the Bureau officers.
Bureau officers can be present and assist prosecutors at plea and sentencing negotiations upon consent of the parties.
The MOU and the Immunity and Leniency programs formalize how the Bureau and the PPSC work together during the investigation and prosecution phases. But we also work to foster a collaborative relationship in other ways. The PPSC has a special competition law section that prosecutes offenses under the Competition Act. These prosecutors have expertise in the legislation and understand the seriousness of cartel offenses. Having a specialized unit dedicated to prosecuting cartel offenses ensures that these types of prosecutions remain a priority. It also enhances the relationship between our two organizations because Bureau officers regularly work with the same group of counsel. In addition, over the years, investigators from the Competition Bureau have come to work at the PPSC. This can help improve the relationship between our two organizations as these counsel have formed strong relationships with their former investigator colleagues. They bring the Competition Bureau's perspective to their work at the PPSC and the prosecutor's perspective to investigations if they return to the Bureau. The public prosecutors may also provide legal advice on Bureau policies and procedures. They may also provide information and training sessions, often in conjunction with Bureau trainers. This advice and training helps ensure that investigations follow the appropriate legal standards and that operational decisions during an investigation, to the extent possible, do not harm future prosecutions.
Valerie and I meet regularly to discuss priorities, consult each other on the use of resources, and talk about any broad issues that come up on any particular case. We are very open and honest in our discussions. These meetings are extremely valuable, particularly since Valerie's position of team leader enables her to have a broad overview of all the cases in the competition law section. This can help foster consistency in our approach to cases and policy issues. We have also hosted gatherings over meals to try to build the personal relationships among employees at the two agencies. Although our organizations generally work well together, we do face some challenges. One challenge results from the division of roles. Most of the cases investigated by the Bureau are complex, and investigators can work on them for years. Sometimes it is difficult for the case team to accept a prosecutor's decision once the case has been referred to them. For instance, if the prosecutor decides not to prosecute the case. We try to overcome this challenge by assigning counsel to the file at the start of an investigation and involving them throughout to ensure that the investigators and prosecutors are on the same page and can address issues and problems early on. However, this is not always successful. Owing to resource constraints, cases are sometimes reassigned, requiring a new prosecutor to start from scratch. Different counsel may have varying views on approach, which could lead to different outcomes. In addition, it is not uncommon to assign a new counsel to review the referral package. Investigators also try to facilitate the PPSC's decision by providing the referral and disclosure packages in their desired format. As is the case in many types of long and complex investigations, unexpected issues can sometimes arise, creating additional tension.
Resource constraints represent a challenge for both of our agencies. To make the best use of our limited resources, we meet regularly to discuss priorities, as Anne mentioned.
Resource constraints sometimes make it difficult to get the PPSC's input on policy matters because they are so busy with casework. The Bureau seeks to continually update or implement new policies and procedures to improve its work and facilitate the work of our prosecutor colleagues. But sometimes they do not have time to provide input. To address this, together we prioritize which ones are the most important or will have the greatest impact on investigations.
As we described, there can be some challenges when two separate agencies work together. To address these challenges, we have formalized our roles in an MOU and the immunity and leniency programs. We also work continuously to enhance our relationship. We are on the right track and look forward to our future work together in the fight against cartels.
Should you have any questions, please don't hesitate to reach out to Valerie and me.
We hope this was helpful, and thank you for taking the time to view this video.
É uma satisfação conversar contigo neste vídeo que espero inspire boas práticas de relacionamento entre autoridades criminais e administrativas em jurisdições associadas à ICM. Em primeiro lugar, seria interessante se você expusesse brevemente a razão pela qual a coordenação entre a atividade administrativa e criminal pode ser útil no combate aos cartéis.
Bom dia, Rodrigo. É uma satisfação recíproca. Agradeço ter aceitado o convite para que registremos as boas práticas e experiências entre o relacionamento de nossas instituições. Sobre a pergunta, é importante contextualizar. Do ponto de vista comparado, alguns países processam cartel apenas na esfera administrativa e outros apenas na esfera criminal. É certo que para estes países falar em coordenação é um tema marginal, aplicável apenas a casos em que cartéis são cometidos em conjunto com outros tipos de infração. Há um conjunto de países, contudo, que responsabilizam cartéis tanto administrativamente quanto criminalmente, às vezes com diferentes enfoques conforme se trata de pessoas físicas ou jurídicas. A coordenação desse país é uma necessidade evidente, tendo em conta a economia de escopo do exercício das competências. Este é o caso do Brasil.
Mas veja que nos sistemas de dupla esfera de responsabilização, as decisões criminais e administrativas são, em regra, independentes. Diante disso, por que ainda faz sentido cooperar?
É um ponto relevante. O controle penal e o administrativo têm finalidades sociais distintas. Por conta disso, são independentes. Em regra, não é obrigatório que exista troca de informações e nem mesmo harmonia total entre as decisões destas distintas instâncias. No entanto, se a qualificação jurídica pode divergir de acordo com a finalidade de cada uma das instâncias, os fatos são de interesse comum. Assim, os esclarecimentos alcançados, por um lado, podem ser aproveitados pelo outro. Em um segundo lugar, do ponto de vista das políticas de acordos para a detecção de ilícitos, como são os programas de leniência e de colaboração premiada, há uma externalidade cruzada positiva na atuação do CAD e do MP. Vale dizer, será tanto mais efetiva a aplicação da lei penal ou da lei administrativa, quanto maior seja o interesse dos agentes violadores em buscar e delatar. Baixa efetividade de aplicação da lei, ao contrário, diminui o interesse no acordo, porque há menor receio de imposição das consequências legais em razão dos malfeitos. Em terceiro lugar, e novamente tendo em conta a política de leniência antitruste, uma ação cooperativa aumenta a atratividade do programa, porque aumenta a estabilidade do acordo assinado, garantindo a entrega dos benefícios administrativos e penais ao colaborador que cumpre as obrigações assumidas. Então, sim, apesar da independência das instâncias, existem fortes razões para buscar a cooperação.
Entrando um pouco mais no procedimento de atuação conjunta entre o CAD e o Ministério Público nos acordos de leniência, aqui no Brasil, o órgão encarregado por receber os pedidos de acordo antitruste é o CAD. Como e quando vocês decidem buscar a intervenção do Ministério Público em um caso desses relacionados ao antitruste?
Normalmente nós buscamos o Ministério Público quando constatamos que o pedido é suficientemente consistente, quando ele é o caso que já merece o olhar ministerial para assinatura. Não são todos os pedidos que geram acordo, muitos são rejeitados. Em geral, pedidos são rejeitados quando há insuficiência de provas ou quando há ausência da indicação de informações que nos permitam esperar reunir provas via as diligências próprias. Nossas estatísticas indicam que a cada 3 pedidos, 2 são rejeitados por algum desses problemas. Então, é uma medida, sobretudo, de racionalidade, buscar o Ministério Público apenas para casos suficientemente consistentes. Excepcionalmente, pode ser o caso de buscar o Ministério Público já na fase inicial de negociação, para casos que estão em andamento e que se recomende tentar interceptação de comunicações telefônicas, por exemplo. Como a Constituição do Brasil exige processo criminal para ser possível a interceptação, pode ser recomendável buscar o contrato já no início das negociações, quando o caso se mostre suficientemente promissor e a conduta ainda esteja em curso. Quanto ao procedimento, seguimos os seguintes passos. Primeiro, é buscado contato com o Ministério Público com competência material e maior proximidade sobre os fatos, mediante o envio de ofício reportando genericamente a existência no CAD de apuração de infração à ordem econômica. Segundo lugar, é agendada uma reunião sigilosa para expor os detalhes do caso. Em terceiro lugar, são realizados ajustes solicitados pelo Ministério Público para esclarecimento dos fatos ou para ajustes em cláusulas específicas do acordo. Após essas etapas, o acordo de leniência é assinado com a documentação completa em 3 vias, uma para cada um dos participantes, uma para o CAD, uma para o Ministério Público e uma para o signatário. A documentação do CAD origina um processo administrativo de apuração e a do Ministério Público, normalmente um processo criminal. No processo administrativo podem ser responsabilizadas pessoas jurídicas e físicas, enquanto que no processo criminal se trata especificamente e exclusivamente de pessoas físicas. Rodrigo, agora fizemos algumas considerações sobre a importância da coordenação entre o CAD e o Ministério Público. Eu gostaria que você registrasse como investigações administrativas podem ajudar o trabalho do Ministério Público.
Claro, bom, investigar é uma atividade por si só intensiva, uma atividade de trabalho intensiva. É assim do ponto de vista da realização do serviço, da descoberta de fatos. Um número maior de investigadores pode, evidentemente, permitir um conhecimento mais profundo daquele fato potencialmente criminoso. O Ministério Público brasileiro, é importante que se diga, ele é responsável por perseguir e por investigar uma ampla gama de violações, ou seja, fatos que apresentam diversas características e tipos, a maioria não relacionada à matéria antitruste. E esta é a realidade não somente, diga-se de passagem, do Ministério Público, mas também das polícias do Brasil, né, das várias polícias civis e a Polícia Federal. O que o CAD efetivamente me parece agrega no assunto relacionado ao combate a cartéis é a sua especialização, ou seja, é um órgão exclusivo para a defesa da ordem econômica. Ele concentra investigadores dedicados apenas aos esclarecimentos de fatos que possam constituir cartéis ou outras infrações à ordem econômica, e dessa forma há inegavelmente um ganho de expertise e também de escala, né? Como a base factual da infração administrativa pode ser plenamente aproveitada no processo crime, é interessante para o Ministério Público acessar esse esforço investigativo do órgão e colaborar com ele.
Isso se aplica da mesma forma no caso de atuação conjunta em negociações de acordo de leniência?
Com certeza, né? De fato, grande parte da negociação de um acordo de leniência, me parece talvez a essência, né, é o esclarecimento de fatos. A cooperação do proponente tem o objetivo de esclarecer os fatos que têm esse potencial criminoso na perspectiva, na visão do Ministério Público. A única mudança se dá quanto à fonte do início da investigação, que costuma ser mais qualificada por confessar a participação, ou seja, aquele sujeito que está no âmago, no interior do delito, e conhecer por dentro todo o arranjo ilícito, todo o arranjo criminoso.
Ainda sobre programas de leniência, como a intervenção do Ministério Público na negociação e na assinatura podem aportar valor?
Bom, o Ministério Público ele é responsável, do ponto de vista constitucional, inclusive, por formalizar acusações criminais perante o Poder Judiciário, incluindo acusações pelo cometimento do crime de cartel. Os tribunais são ambientes onde os processos devem seguir os mais altos padrões do devido processo legal, cláusula constitucional, e o Ministério Público está bem familiarizado, tem a obrigação constitucional de estabelecer justamente este procedimento nos seus mais diversos contextos. A participação do Ministério Público no procedimento de negociação do acordo vem justamente carregado com este olhar, digamos assim, judicial relacionado ao devido processo legal, ao due process of law. Isto certamente pode melhorar, pode contribuir em termos de qualidade para qualquer colaboração relacionada a um acordo de leniência. Um outro aspecto que me parece merece ser mencionado diz respeito à participação do Ministério Público na elaboração do acordo de leniência, na medida em que se proporciona uma maior segurança jurídica. Ou seja, reduz a possibilidade de litígio sobre o processo e o conteúdo dos acordos que foram firmados.
Qual é a melhor estratégia, na sua opinião, para uma colaboração frutífera entre agências de concorrência e membros do Ministério Público?
Bom, excelente pergunta, Eu acho que é importante, em primeiro lugar, conhecer os limites, as vocações e, evidentemente, os poderes e habilidades de cada autoridade em investigar, em identificar, talvez de uma maneira mais efetiva, complementariedades que possam viabilizar uma parceria de sucesso. Bom, do ponto de vista, agora, uma dúvida que surge para você, a mim, para colocar para você, do ponto de vista do CAD, qual que é o maior desafio em ações que tem a coordenação do Ministério Público?
Hoje em dia, o principal desafio é reduzir o tempo de coordenação em alguns casos. Quando não alcançamos trabalhar com promotores ou procuradores especializados, como é o seu caso, como é o caso do Grupo de Combate a Cartéis do Ministério Público Federal em São Paulo, a falta de experiência com questões de concorrência demanda mais tempo de diálogo. É algo natural. Então, não sei se é algo contornável, mas é um desafio. Na perspectiva do Ministério Público, qual é o maior problema na relação com o CAD?
Bom, acho que talvez seria ótimo se o CAD tivesse uma melhor compreensão das especificidades e princípios dos processos que são desenvolvidos no âmbito criminal, pois isso talvez maximizaria as conquistas resultantes das ações de cooperação que são realizadas entre essas duas instituições. Para outras autoridades administrativas que estejam buscando promover ações de cooperação com os ministérios públicos dos seus respectivos países, qual seria, na sua visão, o primeiro passo?
Excelente pergunta, tendo em conta, sobretudo, o público deste vídeo. Os requisitos básicos para uma cooperação efetiva são identificar qualidades complementares de ambas as instituições e visualizar ganhos recíprocos da relação. Exige-se ainda cumprir as disposições legais do seu país e estar entusiasmado com a criação de valor público. Do ponto de vista prático, o primeiro passo é fazer um telefonema, uma videocall ou uma reunião e começar a falar sobre a parceria.
Since August 2016, a criminal cartel offence has officially been reintroduced into Chilean competition laws. Price fixing, market sharing and bid rigging can now be punished with a 10-year prison sentence for the individuals involved. This is in addition to the fines that can be imposed by a specialised competition court. The Competition Act provides that the administrative and criminal prosecution should be consecutive, the latter being conditioned to the submission of a claim by the competition agency, the FNE, once the competition court has delivered a final and binding decision establishing the existence of a collusive agreement. The Act also provides some of the steps through which the FNE and the public prosecution must coordinate their actions. After a claim is submitted, the FNE has conferred the rights of a private claimant. The administrative investigation and the litigation before the competition court is concluded, the FNE will act as a plaintiff alongside the public prosecution and will intervene actively at every stage of the criminal procedure until a final judgment is issued by the criminal court. Evidence obtained by the FNE using intrusive measures, such as dawn raids, phone tappings, etc., is understood by law to comply with the provisions of the criminal procedure and may be adduced to the criminal trial. Thus, it is expected that the FNE will convey all the evidence gathered during the administrative investigation phase to the public prosecution. The Competition Act states that if the public prosecution intends to adduce confidential information as evidence to the criminal process, it must seek the approval of the competition tribunal. Thus, the disclosure of commercially sensitive information will be subjected to the prior assessment of a specialized tribunal on the basis of a reasoned decision. The law also provides that first-in applicants rewarded with the amnesty by the FNE are exempted of criminal liability, while the second applicant, rewarded with a reduction of the administrative fine, shall be also granted a reduction of the criminal penalty. However, beneficiaries of the leniency program are expected to appear before the criminal court at the request of the public prosecution and ratify all depositions submitted before the FNE during the leniency process. Failing to do so without justified cause may lead to harsh consequences, the revocation of all leniency-related rewards, triggering complete criminal liability. In June 2018, the FNE launched the internal guidelines for filing criminal claims for cartels. This document specifies the general criteria under which the FNE will exercise its authority to file criminal claims for cartel offences. The FNE has thereby recognised the importance and the deterrent effect of criminal sanctions for this type of anti-competitive behaviour and has commended to prosecute all forms of hardcore cartels that seriously affect competition in the markets. In 2016, a criminal cartel offence has officially been reintroduced into Chilean competition laws. Price fixing, market sharing and bid rigging can now be punished with a 10-year prison sentence for the individuals involved. This is in addition to the fines that can be imposed by a specialised competition court. The Competition Act provides that the administrative and criminal prosecution should be consecutive, the latter being conditioned to the submission of a claim by the competition agency, the FNE, once the competition court has delivered a final and binding decision establishing the existence of a collusive agreement. It also provides some of the steps through which the FNE and the public prosecution must coordinate their actions. After a claim is submitted, the FNE is conferred the rights of a private claimant. This means that when the administrative investigation and the litigation before the competition court is concluded, the FNE will act as a plaintiff alongside the public prosecution and will intervene actively at every stage of the criminal procedure until a final judgment is issued by the criminal court. The evidence obtained by the FNE using intrusive measures, such as dawn raids, phone tappings, etc., is understood by the law to comply with the provisions of the criminal procedure and may be adduced at the criminal trial. Thus, it is expected that the FNE will convey all the evidence gathered during the administrative investigation phase to the public prosecution. The Competition Act states that if the public prosecution intends to adduce confidential information as evidence to the criminal process, it must seek the approval of the competition tribunal. Thus, the disclosure of commercially sensitive information will be subjected to the prior assessment of a specialized tribunal on the basis of a reasoned decision. The law also provides that first-in applicants rewarded with amnesty by the FNE are exempted of criminal liability, while the second applicant, rewarded with a reduction of the administrative fine, shall be also granted a reduction of the criminal penalty. However, Beneficiaries of the leniency program are expected to appear before the criminal court at the request of the public prosecution and ratify all depositions submitted before the FNE during the leniency process. Failing to do so without justified cause may lead to harsh consequences: the revocation of all leniency-related rewards, triggering complete criminal liability. In 2018, the FNE launched the internal guidelines for filing criminal claims for cartels. This document specifies the general criteria under which the FNE will exercise its authority to file criminal claims for cartel offences. The FNE has thereby recognized the importance and the deterrent effect of criminal sanctions for this type of anti-competitive behavior, and has commended to prosecute all forms of hardcore cartels that seriously affect competition in the markets.